In July 2025, Bolt CEO killed their unlimited PTO policy and replaced it with mandatory vacation time. His reason? Quote, "When time off is undefined, the good ones don't take PTO. The bad ones take too much." But here's what he didn't mention publicly and what your leadership team probably doesn't know. Unlimited PTO policies have triggered lawsuits costing nearly $500,000 for just 3 employees. If your company is considering unlimited PTO or already has it, there's a legal minefield hiding under that unlimited label that could cost your organization 6 figures per employee. I'm Alex Castro, a Florida licensed labor and employment attorney with AXC Legal located in Fort Lauderdale, Florida. I help South Florida HR teams identify compliance traps before they become expensive lawsuits. Companies pay out massive settlements for policies that looked attractive on paper but create devastating liability in practice. Remember, this is general information only, not legal advice. Every employment situation is unique and requires individualized evaluation. Your CEO probably loves unlimited PTO because it sounds generous, helps recruit talent, and here's the real reason, eliminates accrued vacation liability from your balance sheet. Your CFO sees it as a financial win. Your executives thinks it's modern and progressive. And if you're in HR, you might have been told this policy will save you time because you won't have to track vacation accruals anymore. Most HR teams implementing unlimited PTO believe they're reducing compliance work and eliminating payout obligations. On paper, it makes perfect sense. But here's what employment attorneys know that most HR professionals don't realize until it's too late. Unlimited PTO doesn't eliminate legal liability, it multiplies it across 5 different categories of employment law violations. According to one of the few published appellate cases with documented court awards, 3 employees with an unlimited PTO policy walked away with nearly $500,000 in damages and attorney's fees. The court awarded them 20 days of vacation per year, even though the policy was supposedly unlimited with no accruals. And that's just one category of liability. There are 4 more legal traps that can turn your generous benefit into an HR compliance nightmare that keeps you up at night. Today, I'm breaking down the 5 critical legal vulnerabilities hiding in unlimited PTO policies, why experienced HR professionals have rejected this benefit for 22 years, and the specific red flags that trigger lawsuits so you can either avoid this trap entirely or audit your existing policy before it explodes into 6-figure liability. In California, a nonprofit organization implemented an unlimited vacation policy for their exempt area managers. The policy was never formalized in the employee handbook, just communicated verbally and through emails. HR told employees they could take time off whenever they wanted, subject to manager approval and business needs. On the surface, this looked like a generous, flexible benefit that would attract top talent while eliminating the company's accrued vacation liability on their balance sheet. Most HR teams would look at this and think, clean, simple, no accruals to track, no big payout when people leave. Here's where it went catastrophically wrong. 3 employees filed the lawsuit claiming they were owed vacation pay when they left the company. The employer argued, "We had unlimited PTO, there's nothing to accrue, nothing to pay out." But the California Court of Appeal looked at what was actually happening at this company and found 7 fatal flaws. First, the policy was never formalized in writing. Second, employees were never explicitly told the policy was unlimited. Third, employees were working 100-hour weeks during peak seasons, making it practically impossible to take substantial vacation. Fourth, taking time off during busy periods was strongly discouraged by management. Fifth, workload prevented employees from taking more than 2 to 6 weeks annually despite the unlimited label. What the court found was that this policy had implied limits, and when there are implied limits, vacation becomes determinable and payable at termination under California law. The result? 3 employees were awarded $88,590 in direct damages. But here's where it gets exponentially worse for the employer. Attorney's fees came out to $397,700. Total cost to the company, $486,290 for 3 employees who supposedly had unlimited vacation that required no payout. And that was just for 3 employees. Had the case become a class action with all similarly situated employees, the damages could be astronomical. Employment attorneys read that opinion and immediately started looking for companies with the same vulnerabilities because so many companies handle PTO similarly. This case is called McPherson versus EF Intercultural Foundation, decided by the California's Court of Appeal in April 2020, and every employment lawyer in the country knows about it. Here's what the California court said unlimited PTO policies should consider including to avoid this disaster. First, explicit written language stating that PTO is not a form of earned wages for work performed, but part of the company's commitment to flexible scheduling. Second, clear rights and obligations for both employer and employee so that employees who don't schedule PTO understand the consequences of not using it. Third, sufficient opportunity for employees to actually take substantial time off. Fourth, fair administration preventing the policy from becoming effectively a use it or lose it policy and preventing inequities between employees and how they use their PTO. If your policy doesn't have all 4 elements documented in writing, you're sitting on the same liability time bomb that cost this employer nearly $500,000. That protects you from the payout trap, but there are 4 more legal catastrophes hiding in unlimited PTO policies that most HR teams don't see until the lawsuit arrives. But here's what catches HR teams completely off guard. 20+ states require vacation pay at termination. California explicitly prohibits vacation forfeiture, and any agreement attempting to forfeit earned vacation is void under Labor Code Section 227.3. Colorado passed similar protections in the Nieto case in 2021. Massachusetts treats unpaid vacation as wages subject to treble or triple damages under their Wage Act. Montana, Nebraska, Illinois, Louisiana, Maine, Rhode Island, and North Dakota all have mandatory payout provisions. And many other states also require PTO payouts if your handbook doesn't have some magic language in it. But if your unlimited PTO policy has any implied limits through workload, manager denials, or cultural expectations, courts in these states may calculate what employees were entitled to take and require full payout at termination. And they calculate generously. Here's what happens in practice. Long-tenured employee in California works for you 5 years under an unlimited PTO policy. When they leave, you owe nothing according to your policy. Employee consults attorney. Attorney identifies workload constraints, manager verbal statements about typical vacation amounts, or patterns showing employees taking 2 to 6 weeks annually. Attorney files claim arguing the policy had implied limits making vacation determinable. Court awards 20 days per year, the maximum the court found possible for that position level, multiplied by 5 years of service. That's 100 days of vacation pay. California's waiting time penalties can double or triple that amount if you didn't pay promptly. Attorney's fees get added on top of that. Suddenly, your zero liability policy created $50,000 to $150,000 in damages per employee. Here's your compliance protocol for state payout laws. First, map every location where you have employees against state vacation payout requirements. California, Colorado, Massachusetts, Montana, Arkansas, and Nebraska are all highest risk. Second, if you operate in any mandatory payout state, document in writing that your unlimited PTO policy is truly unlimited with no implied caps, and make sure that that policy matches reality. Third, ensure workload actually allows employees to take substantial time. If people can't take more than 3 weeks due to job demands, you have an implied cap. Fourth, train managers never to make verbal statements about typical or reasonable vacation amounts because those create implied limits. Fifth, track actual usage patterns. If everyone's taking 2 to 6 weeks, that range becomes your implied policy and triggers payout obligations. Now your state law exposure is contained, but there's a federal compliance disaster you may not know about. But here's the problem employment attorneys are starting to exploit. FMLA regulations require employers to allow employees to substitute accrued paid vacation leave during FMLA leave. If your policy provides unlimited vacation for leisure trips to Europe, but you make FMLA leave unpaid, employment attorneys will argue that employees are entitled to full pay during the entire 12-week FMLA period because paid vacation is unlimited. You can't say yes to unlimited vacation for fun, but no to paid vacation during protected medical leave. That creates FMLA interference and discrimination claims. Additionally, unlimited PTO obscures whether absences are FMLA qualifying. Employee takes PTO for illness without completing FMLA paperwork. You don't designate it as FMLA because they just called it PTO. Later, you discipline them for unreliable attendance even though you have unlimited PTO. Turns out, some of those absences should have been FMLA protected. Now, you have FMLA retaliation and interference claims that can cost $50,000 to $100,000 in settlements. Here's a real-world scenario. Employee needs FMLA leave for serious health condition. Requests 12 weeks off. You approve the FMLA leave but tell them it's unpaid after any accrued sick leave runs out. Different employee takes 4-week vacation to visit family overseas, fully paid under your unlimited PTO policy. First employee files FMLA interference and disability discrimination complaint arguing you paid vacation for leisure, but not for protected medical leave or disabilities. Settlement value? $60,000 to $120,000 because you treated FMLA qualifying leave differently than vacation leave under the same unlimited policy. Here's how to protect yourself. First, decide whether FMLA qualifying absences will be paid under your unlimited PTO policy and document that decision clearly in your FMLA policy. Second, if you make FMLA unpaid, prepare to defend why unlimited PTO doesn't have to extend to protected leave. Third, track all absences to identify FMLA qualifying events even when employees just request PTO, at least in the states you're allowed to ask for the reason for PTO. Fourth, train managers that unlimited PTO doesn't eliminate FMLA designation requirements or the need to loop HR in. Fifth, never deny PTO requests that could qualify as FMLA without proper FMLA process. The Department of Labor issued guidance in January 2025 specifically addressing PTO substitution during FMLA. compliance is getting more complex, not simpler. Here's the trap. State laws requiring sick leave accrual don't care that your PTO is unlimited. California, Colorado, Arizona, Massachusetts, and 16 other states require tracking hours worked, calculating accrual, reporting balances on pay stubs, and maintaining carryover amounts. California Labor Code Section 226 and 246 specifically requires itemized wage statements to include PTO available. If you're providing unlimited sick leave, you must state unlimited on every pay stub. Oregon and Maryland require reporting accrued sick leave balances. Your unlimited PTO policy doesn't exempt you from these requirements, it just makes compliance more confusing because you're not tracking anything. Violations carry penalties of up to $4,000 for a single employee. For a company with 100 employees, that's potential damages of $400,000 just for pay stub violations. And that's before you even add in attorney's fees and costs, which can likely add over several hundreds of thousands of dollars. Additionally, state sick leave laws include specific anti-retaliation provisions. If a manager denies a PTO request that qualifies as sick leave without a qualifying exception, even under your unlimited policy, you've violated state sick leave protections. Employee takes time for protected sick leave reason. Manager later denies different PTO requests citing excessive absences. That denial can trigger sick leave retaliation claims under state law with automatic penalties and attorney's fees. Employment attorneys specifically look for this pattern because it's easier to prove and settlements are predictable. Here's your mandatory compliance fix. First, separate unlimited vacation from limited accrued sick leave. Do not combine them into one unlimited PTO bucket if you operate in any state with mandatory sick leave laws. Second, track sick leave accruals and usage separately even if vacation is unlimited. Third, report sick leave balances on pay stubs as required by state law. Fourth, train managers that sick leave requests have different legal protections than vacation requests. Fifth, audit your unlimited PTO policy against every state where you have employees. If even one state requires sick leave accrual, your policy needs restructuring. But here's what creates discrimination liability. Without clear approval criteria, each manager develops their own unwritten rules. Marketing manager approves most requests freely, engineering manager is stringent, requiring detailed justification. Sales manager denies requests during Q4 regardless of reason. Now you have department level disparities in access to your unlimited PTO benefit. If those disparities correlate with protected class demographics, marketing skews female, engineering skews male, sales has more employees over 40, you've created discrimination exposure. Courts look at patterns. Employee in protected class takes 2 weeks annually despite requesting more, and requests are frequently denied. Different employee in non or different protected class takes 6 weeks annually, requests are approved freely. Both have the same job level and performance ratings. That's textbook disparate treatment supporting discrimination claims frequently worth $60,000 to $150,000 in settlements. And here's another real pattern that triggers lawsuits. International employees need 2 to 3 week blocks for overseas family visits. Managers uncomfortable with longer requests. Pattern emerges where 1 week requests get approved, but 3 week requests get denied. This creates national origin discrimination exposure. Or parents, particularly mothers, use time incrementally for child illness and school appointments, but appear to be always out despite taking fewer total days. Manager perceives unreliability, denies future requests. That's family status and sex discrimination and maybe even FMLA interference. Or employees with disabilities use time for medical appointments. Manager uncomfortable with excessive medical absences denies subsequent requests. That's disability discrimination under the ADA and FMLA interference. The unlimited label makes this worse because employees can point to colleagues taking more time and ask why they're being treated differently when supposedly everybody gets unlimited. Here's how smart HR departments prevent discrimination claims. First, establish written approval criteria that managers must follow consistently. Define what business needs means with specific examples. Second, require documentation of every denial with business justification unrelated to protected characteristics. Third, audit approval patterns quarterly across departments and demographics. If you see disparities, investigate immediately. Fourth, train managers that unlimited PTO doesn't mean unlimited discretion. Denials must be applied consistently regardless of who's requesting time. Fifth, track actual usage by employee demographics. If protected classes are taking significantly less time than non-protected classes, you might have a discrimination problem that needs immediate attention. Now here's why this matters beyond just the legal liability. After 22 years since Netflix pioneered unlimited PTO in 2003, only 6 to 8% of employers have adopted it. That's not because HR professionals don't know about it, it's because experienced HR teams recognize the risks outweigh the benefits. SHRM surveys showed adoption plateaued at 6% in 2019 and 2022. It ticked up slightly to 8% in 2023, but growth stalled in 2024. Job posting data tells an even clearer story. Mentions of unlimited PTO in job postings peaked in March 2022 at 8.8% of postings, then declined to 40% by June 2023. As of June 2025, only 2.9% of job postings mention unlimited PTO at all. Companies are quietly abandoning this policy. Bolt eliminated it in July 2025. Kickstarter eliminated it in 2015 after finding employees felt uncertain about appropriate amounts. Tribune Publishing rescinded their policy within 2 weeks due to massive employee backlash. The reason? The researchers call it the unlimited PTO paradox, where employees actually take less time with unlimited policies. Studies show employees take 10 to 13 days with unlimited PTO versus 15 days with traditional accrual policies. High performers burn out because they don't know when to stop. Low performers take excessive time. It creates inequity across your workforce. And here's what makes this particularly problematic for HR. Your executives want unlimited PTO to eliminate balance sheet liability. Your CFO sees it as a financial win. Your CEO thinks it's modern recruiting appeal. But you're the one who deals with the lawsuits when it goes wrong. You're the one tracking FMLA, sick time, auditing for discrimination, defending denied requests, and explaining to terminated employees why their unlimited vacation is worth nothing. The policy creates more compliance work for HR, not less, because you still must track sick leave in 20 plus states, designate FMLA leave, monitor for pattern discrimination, and document every denial. The disconnect between what executives think they're getting and what HR actually has to manage creates a disaster. Remember, implied limits can trigger $100,000 plus payout obligations in California and other mandatory payout states. FMLA complications can create $60,000 to $120,000 in discrimination, retaliation, and interference liability. Sick leave law violations across 20 plus states carry penalties per violation per pay period. Manager discretion without clear criteria creates discrimination exposure worth $60,000 to $150,000 per claim. And all 5 categories can apply simultaneously to the same policy, multiplying your total exposure. Here's the math that matters. The $486,290 that one employer paid for 3 employees would have funded comprehensive policy reviews for their entire organization for a decade. One lawsuit cost more than 10 years of prevention. The math isn't even close. This is exactly what I audit for HR departments before problems arise. Because the McPherson case proved that fixing these gaps after a lawsuit costs 50 times more than preventing them. HR professionals, you are the frontline protection against these expensive disasters. If your leadership team is pushing for unlimited PTO, you now have the specific legal ammunition to push back. If you already have an unlimited PTO policy, getting a policy audit could be the difference between a compliant benefit and a 6-figure lawsuit per employee. A proper unlimited PTO compliance review brings you peace of mind, shields your company from catastrophic liability, and reinforces the excellent protective work your HR team already does. If you're unsure whether your unlimited PTO policy has these hidden legal traps, you may want to consult with a qualified employment attorney who can evaluate your specific policy language and implementation. The link to schedule a policy review is in the description below. You don't have to navigate this alone. Let's make sure your policies protect your company instead of creating hidden legal exposure. Thanks for watching, and thank you for doing the hard work of protecting your organization from compliance disasters.